Thank you very much, and welcome to Litigating Health and Security Exceptions in Investment Treaties. I'm really excited to be bringing you this event today as part of the annual meeting. My name is Ben Heath. I'm a professor at Temple University School of Law. I want to thank ASIL for having us and also extend a special welcome to the students who have signed up for the meeting and are attending. As a professor, it's very exciting to see students take time out of their busy schedules to come to these events. And so I really appreciate that. And I know my colleagues do as well. So this panel is going to be something a little bit different from what we usually do. And in a way, I think that's going to be very exciting for everybody. So the events of the past year have caused many to wonder, especially in the investment field, how the investor-state dispute settlement system is going to deal with a major public health crisis. So we're already seeing COVID test the system in various ways. So we're seeing parties request more time. We're seeing the challenge of remote hearings. We're even seeing some parties requesting relief from large damages awards. And we are also seeing some movement, slow and halting, some threats toward bringing claims for measures arising out of the pandemic. And so what we thought we would do with this event is simulate the early stages of an investor-state dispute settlement claim arising out of the COVID-19 crisis. And so this is going to be a simulated case with entirely made-up facts that arises directly out of a state restriction addressing the pandemic. So what I'm going to do as a little intro is I'm going to describe the facts, and then I'm going to introduce you to your panel. You're going to hear an argument about security exceptions, health exceptions, and COVID restrictions. And you are also going to vote. You're going to vote at the outset in just a couple of minutes on whether you think the case should be dismissed. And you will vote again at the end. And we're going to see if the advocates have persuaded you to change your minds. So the first thing I'm going to do is I'm going to introduce the facts a little bit. And these are stylized facts. They are totally made up. They're a little bit more streamlined than what a real case would be like. And this is a summary of a document that should be available to you if you scroll down on the events page and you look at the bottom. There should be a PDF file that has a longer summary of the facts. You can look at that and follow along at your leisure. So the claimant in this case is Jazz Age LLC. Jazz Age is an upscale restaurant chain. They are a company based in the country of Caledonia and operating a series of restaurants in the neighboring country of Riza. The business model of Jazz Age is an intimate nightlife experience. They invite small groups to experience an evening of jazz and music and culture and wine and good food. The layout of these restaurants is actually quite coincidentally very well set up for social distancing. But one problem is that Jazz Age operates exclusively at night. And that's going to be important in just a minute. When the COVID-19 pandemic hit, Riza shut down all bars and restaurants, as many states, countries, and municipalities did. And when the country started to reopen as cases subsided, Riza adopted what we're calling a mandatory closure rule. All bars and restaurants had to be closed for the night at 8 p.m. This rule effectively made it impossible for Jazz Age to continue operating in Riza, and Jazz Age has had to shut down all of its locations. Now, why did Riza adopt this rule? COVID, of course, does not only come out at night. It's not more dangerous at night. But Riza officials worried that late night drinking especially could lead people to disrespect social distancing rules. And they also thought this 8 p.m. closure rule might have benefits in reducing crime and disorderly conduct. So Jazz Age has now brought an arbitration against Riza under the Caledonia-Riza Investment Treaty, alleging that this measure is arbitrary, raising concerns about the process by which it was adopted, alleging that it is discriminatory vis-a-vis other more unsafe and nationally owned restaurant chains that are nonetheless able to continue operating during the day. And that all of this amounts to an indirect expropriation of Jazz Age's investment. RISA disputes all these claims on the merits, but they also counter that the measures are entirely covered by an exception in the investment treaty. This exception allows any action which is directed to the protection of either state's essential security interests or directed to public health. RISA is seeking to dismiss this claim at an early stage as a preliminary matter because by virtue of this exception, Jazz Age's claims are manifestly without merit within the meaning of ICSID Arbitration Rule 41, paragraph 5. You are about to see the closing arguments on RISA's request to dismiss the case as a preliminary matter. If RISA prevails on this preliminary objection, then the case is over. If RISA loses the preliminary objection, the case will proceed. It will proceed to briefing on jurisdiction and the merits and the tribunal's discretion as to how to order that. It will proceed to document discovery and potentially other procedural developments. And RISA will be able to re-raise the objection as an objection on jurisdiction or an objection on the merits or both. So what we're looking at now is something in the nature of a motion to dismiss, a preliminary motion. So you are about to see a poll. Take a minute to take a look at the facts and decide whether you think, on this brief summary of the facts and what you see in the document, whether RISA should prevail on this preliminary motion. And in a second, I will report the results of that poll. So as we're waiting on results, I'd like to introduce you guys to our esteemed all-star cast of panelists and counsel. So acting as claimants counsel, we have Ina Popova of Debevoise and Plimpton. As respondents counsel, we have Justin Asinto of Curtis Mallet Prévost, Colt and Mosley. As a co-arbitrator appointed by the claimant, we have Sabina Sacco of Sabina Sacco Arbitration LLC. That's a small correction to the program. As a co-arbitrator appointed by respondent, we have Tafadzwa Pasipanoja of Foley Hoag. And as our esteemed tribunal president, we have Sama Haridi of Hogan Lovells. Now, I should say, I think I speak for all the panelists when I say that all the positions taken here are entirely in their personal capacity and not even necessarily reflective of their own personal opinions, much less those of any of their clients or other folks they represent. This is a simulation that is designed to experiment with how we are going to deal with crises such as the COVID-19 pandemic in investor-state arbitration. Now, I am seeing results from the poll, and I see that we have 66% saying that the respondents' objection should be upheld and the case dismissed, and 34% saying it should not be and the case should proceed. So we'll see if that changes as we dive in. So with no further ado, Madam President, I'm going to turn it over to you to begin the proceedings. Thank you very much.
Thank you very much, Professor Heath. It is a pleasure to be with you all today. This tribunal is gathered, unfortunately, remotely due to the circumstances of this pandemic. We certainly wish we could do this in person, but here we are on Zoom. As Professor Heath just said, we are here to have or hear from counsel for both parties and hear their closing arguments on the Rule 41.5 preliminary objection, which is, of course, filed and submitted by the respondent. So we are going to proceed in the following fashion. We're going to hear first from respondent, and we have agreed prior to this hearing that each side will have 13 minutes, 1-3, to present their arguments, followed by rebuttals from each side for a total of 2 or 3 minutes. So let's begin. Without further ado, I'm going to turn it over to Respondents' Counsel for his argument. Thank you.
Thank you, Madam President, members of the Tribunal. As you have our submissions on the operation of ICSID Rule 41.5, I will not repeat our arguments on that issue here. My focus will instead be on the substance of respondents' objection that claimants' claims are manifestly without legal merit. Article 11.3 of the treaty reads, quote, "The provisions of this agreement shall not in any way limit the right of either contracting party to take any action which is directed to the protection of its essential security interests or to the protection of public health." The effect of the "not in any way limit" language is clear. It means that if a state action is found to be within the scope of Article 11.3, the treaty standards of treatment are inapplicable, and any claims based on that action must be dismissed. What then is the scope of Article 11.3? It applies to any action which is directed to the protection of the state's essential security interests or to the protection of public health. That is an unusual formulation. Typically, the exceptions clauses of treaties take one of two other forms. The first form is the expressly self-judging exception clause that has been used in many areas of international law. A notable example is GATT, Article 21, which states, "Nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests." The inclusion of the "it considers necessary" terms make it clear that the states intended this type of clause to be self-judging. That is not disputed. There is, however, a debate as to whether the clause is completely self-judging and that its invocation by the state settles the matter, or whether a tribunal should undertake what is often referred to as a good faith review to assess whether the state actually considers that the measure is necessary for the protected purpose. The second common clause form is similar, but does not include the "it considers necessary" language. There is also a debate on how this type of clause is to be interpreted. States have argued that they are also self-judging, and investors have argued otherwise, asserting that the tribunal must determine whether the challenged action was in fact necessary for the protected purpose. We do not need to engage in that debate here. Rather than saying if the state considers, Article 11.3 specifies that measures are excluded if they are directed to the protected purposes. As such, the clause provides no textual basis for a review to determine whether the state genuinely considers that the clause applies. Article 11.3 also does not require that the measures are necessary. Rather, it provides that any action is excluded as long as it is, quote, "directed to the protection of its essential security interests or to the protection of public health." As such, the merits of the measure are irrelevant. It does not matter whether the science justifies the measure or whether the intervention was effectively designed. The adequacy of the procedure followed by the state in taking the measure is also irrelevant. All that matters is whether the state directed the measure to one of the protected purposes. Claimant has argued that our interpretation cannot possibly reflect the state's intent because it results in such a strong exception. We disagree. There are very good reasons for states concerned with protecting their regulatory and policy space to have chosen such a clause. Consider what can happen in a case involving a clause that applies to measures that are necessary. If we focus on public health measures, we know that the science regarding both the risk to human health and the efficacy of planned interventions is often uncertain. In many areas of public health regulation, you may need to try something in the hope that it may work without being sure of the outcome. The Philip Morris cases against Uruguay and Australia did not involve an exclusion clause, but I think they're still instructive on this point. Philip Morris did not challenge the overall legitimacy of the tobacco control measures. Instead, it focused on challenging particular aspects of the measures as arbitrary. It argued, for example, that the single variant requirement imposed by Uruguay, which required Philip Morris's Marlboro brand to choose between selling its standard product, Marlboro Red, or one of its other variants, particularly its silver and gold variants, it had to choose one of those three. There were studies showing that consumers held unwarranted views of the health benefits of silver and gold because they continued to see them as lights and ultralights, even though those labels had been banned years earlier. As such, Philip Morris challenged the measure in a more nuanced way. It argued that Uruguay had not established that the single variant ban would result in reduced smoking, as opposed to simply pushing consumers to generic brands. That challenge placed a significant burden on Uruguay. It was the first state to adopt a single variant rule, so it had no record of how such a measure worked in practice. Now, the tribunal applied the FET standard in this case, and so was only concerned with determining whether the measure was arbitrary. One of the arbitrators found that the single variant measure failed to pass even that lower bar. Had the test been whether the measure was necessary, it is quite possible that Philip Morris would have prevailed. There are 2 points to stress from that example. First, needing to prove that a public health measure is necessary is a demanding task, and one that might not be possible to meet. In both environmental and health regulation, it is accepted that states should be allowed to regulate in accordance with the precautionary principle, which recognizes that regulators sometimes need to take action despite uncertainty regarding both the nature of the risk and the effectiveness of the intervention. Second, if a state needs to prove that a measure is necessary to fall within the scope of an exclusion clause, then the clause provides it little actual benefit in practice. It would be easier for the state to disregard the exclusion clause and go right to arguing that the measure is not arbitrary, as that is a lower bar to pass. So I think we can see why states concerned with preserving their regulatory space would not want an exclusion clause that requires them to show that the measure is necessary. It is also understandable that such states would consider a conventional self-judging clause insufficient. Now, your first reaction may be to think that there's no reason a state would object to its measures being tested against a good faith standard, as no state should be concerned with protecting its right to regulate in bad faith. It's not that simple in practice, however. To begin, there is a risk that a good faith review can be very burdensome. In Methanex v. United States, the parties submitted extensive pleadings backed by numerous witness statements and expert reports challenging the merits of a ban on a chemical used as gasoline additive. The tribunal's lengthy award goes through all the disputed science and the allegations of how the measure benefited a domestic competitor before concluding that it was a legitimate regulatory measure and not a sham. It did that in applying the FET standard. We submit that a good faith review under an exclusion clause should not involve such a process, but that is the kind of review that claimant wants you to undertake. The other problem with a good faith review is that, as with the necessity standard, claimants will not limit themselves to questioning the overall legitimacy of the measure. While it may be clear that the disputed action is a bona fide regulatory measure, the claimant will attack the precise manner in which it was designed. And in doing so, they will characterize any indication that the regulator accounted for other factors, including political and economic considerations, as proof of bad faith, warranting a finding of breach. Let me now turn to applying Article 11.3 to our case. If it is interpreted according to its terms, there should be no serious question that respondents' Rule 41.5 objection should be granted. The challenged measure, which is the closure rule applied to claimants' businesses, was adopted in the state of emergency arising from the COVID-19 pandemic. Further, the measure was adopted by RISE's Ministry of Health for the declared purpose of reducing the spread of the pandemic. In addition, the form of the measure was a recognized public health intervention. States around the world have barred indoor dining and drinking because the virus spreads so effectively through airborne transmission in closed spaces. That is all you need to consider in determining whether RISE directed the measure to protecting public health and essential security interests. Whether the science supported the measure, whether the ministry followed an adequate procedure, whether the measure had a discriminatory effect, all of that is irrelevant. Assuming for the sake of argument that the tribunal were to decide that Article 11.3 is subject to a good faith review, despite the absence of the if the state considers terms, respondent's objection should still be upheld. Claimant has no basis for alleging that the measure was a pretext or sham. Rather, it can only point to the rushed manner in which the measure was adopted and the differing effect of the measure on its business compared to other businesses as loose indicia of possible bad faith motives on the part of the ministry. Now, it may be true that the measure was adopted in a rushed manner without the normal consultative process or risk assessment work that would normally be done, but that is because it is a measure adopted to stem the spread of the worst pandemic the world has seen in 100 years. Many states went from barely paying attention to reports of a new respiratory disease appearing in China to locking down major sectors of their economies in a matter of weeks. And the consensus view looking back is that most of them move too slowly. It may also be true that keeping the closure rule in place after 8 p.m. harmed claimants' nightlife business more than restaurants, but that different effect does not constitute evidence of bad faith. It is just a result of the different circumstances of claimants' business compared to restaurants. Ultimately, claimants' defense to respondents' objection is a request that it be allowed to proceed to the merits to see if it can find some way of showing that the challenged measure would not pass a probing review of the sort seen in the Methanix case. It wants to be able to submit a lengthy memorial that will no doubt be backed by many fact and expert statements, casting aspersions of bad faith on the ministry, and then have a chance of finding something either through document production or witness examination that provides support for those aspersions. The claimant should not pass a Rule 41.5 objection on that basis. There is already a broader problem in the practice of investment arbitration of investors layering allegations of bad faith over their claims because they know that tribunals often feel that they need to leave open the possibility that the allegations could be true, with the result that they order wide-ranging document production against the state. Every document relating to the dispute, all internal emails, meeting minutes, reports, etc., all need to be produced because of the possibility that they contain something that evidences bad faith. At times, it can be appropriate for a tribunal to order relatively broad document production, but that is when the claimant has done more to substantiate its allegations. It should not be able to do that on the basis of speculation. Here, there is no reason to believe that the Ministry of Health was unduly affected by improper influences. But let's assume, for the sake of argument, that the discovery process revealed an internal ministry document showing that it accounted for the business interests of restaurants. Claimants like to treat such documents as smoking guns, but legislators and administrative agencies do not operate in a vacuum. Political and economic considerations are almost inevitably part of the lawmaking or rulemaking process. That does not mean that the measure is illegitimate. In sum, the issue before the tribunal is simple. A restriction on indoor dining and drinking adopted by a Ministry of Health to address the COVID-19 pandemic is manifestly a measure directed to the protection of both essential security interests and public health. This is precisely the type of measure that the contracting states wanted to exclude from the treaty. Thank you.
Thank you very much, Mr. Jacinto. The tribunal members have conferred, I should say, before this hearing, and we determined that we would prefer not to interrupt the flow of arguments, so we will reserve our questions until after the rebuttals. So I'm going to turn it over to Claimants Counsel and ask her to proceed with her argument.
Thank you, Madam President. Using the pandemic as a pretext, RISA opportunistically shut down claimants' thriving business without proper process, without rational justification, and without fair compensation. And today, RISA evokes the treaty in much the same way, using Article 11.3 as a pretext. RISA says you cannot even look at its unlawful conduct. But Article 11.3 is not a get-out-of-jail-free card. And more importantly, RISA cannot prove that it is so manifestly a get-out-of-jail-free card that its objection under Rule 41.5 must succeed. Now, the tribunal faces an issue here of first impression, so it helps us always to consider the historical context. Clauses like 11.3 hail from interstate trade agreements like the mid-century GATT, and from there in NAFTA, and then some Soviet-era bits. But out of more than 1,000 investor-state cases, they've arisen in only a handful, often with dissents. And of course, their purpose is to limit state responsibility for unlawful violations of international law. And so the nature of the beast, if you will, is exceptional. And because of that nature, Article 11.3 cannot support Respondent's 41.5 motion to dismiss, whether on jurisdiction or on the merits. First, respondents admitted that the directed to language in 11.3 makes it somehow even more self-judging than clauses that say the state considers. In other words, the science is irrelevant and that what the state considered at the time is irrelevant. Irrelevant. Game over, he submitted. Well, actually, it's the other way around, and this submission is instead an own goal, because even if the word it considers was somehow to transmogrify a clause like this into a self-judging one, Article 11.3 in this case does not contain those magic words, And precisely because it does not contain those magic words, it is not self-judging. And here we can cite several judgments from the ICJ, from Nicaragua and the United States to the latest decision under the Treaty of Amity earlier this year. Again, investment treaty tribunals agree, as the C.C. Davis Tribunal put it back in 2016, this solution is well established. Second, even if it were somehow self-judging, the tribunal could still evaluate whether the clause was invoked in good faith. Again, my counterpart suggested to you that this too is irrelevant, that it could act in bad faith and still get away with daylight robbery manifestly, he said. So they're inviting you to disregard the basic principle of law recognized by civilized nations, that is the principle of good faith. And there is no precedent at all for that. Even states who consider such clauses in trade agreements to be self-judging expect counterparties to invoke them in good faith. Here again, the authorities are not disputed. Look at the ICJ's judgment in Djibouti and France. Look at the WTO panel decisions in Russia, traffic in transit, more recently in Qatar and Saudi Arabia. And similarly in C.C. Davis, if you were to accord a wide measure of deference, because the essential security interest, for example, is an existential matter, you can still challenge whether it was invoked in good faith or bad faith. As the Russia WTO panel put it, an incantation that this clause cannot be an incantation that shields a challenged measure from all scrutiny. And finally, whether self-judging or not, security exceptions are in any event an issue for the merits. They cannot be an obstacle to jurisdiction, as Reisa would have you believe. Again, we see near unanimity in prior decisions. Very recently from the ICJ in alleged violations of the Treaty of Amity, the WTO panel in Qatar, Saudi Arabia, and the TRIPS. And I would say we've heard no authority to the contrary from Reisa. That brings us to the second prong of Reisa's objection on the merits. And here again, Reisa submits you cannot subject its conduct to any kind of scrutiny at all. And that is just as extreme as it sounds. Mr. Jacinto submitted that the science is irrelevant, that the reason for the measure is irrelevant, that the good faith of the state is irrelevant. Now, why would he say that? Because the evidence here does not help Reisa. First of all, look at what the government actually said at the time. Mr. Jacinto didn't address this, but how could Reisa prove that a measure adopted in the government's own words to curb disorderly conduct and other social ills associated with late night drinking and carousing so obviously qualifies as one directed to the protection of public health that it is manifestly meritless to contend otherwise? Now, policing public morals is not protecting public health. This is not the prohibition. And the purpose of Article 11.3 of the treaty is hardly to police how citizens should be spending their evenings or to condone arbitrary rulemaking and hostility against foreign investors. But that is exactly what is going on in this case. And that is why Reisa is so afraid to face the music. Because Jazz Age complied with all of the directives of the health authorities. And let's not forget, it was a classy joint. Entry cost a pretty penny. Conversation is frowned upon during the show. Well-heeled jazz fans aren't exactly prime suspects for disorderly conduct. And that cannot be said for Jazz Age's rivals. At Reisa-owned Bob's Family Style and Mediterranean Tapas, customers sit elbow to elbow, double dip in a shared buffet, and they can drink alcohol all day. Now, those restaurants are an epidemiologist's nightmare. Those restaurants were not shut down. And why? Reisa has given you no answer. And second, even if Reisa could somehow show that its closure order was scientifically justified, it still could not prove that 11.3 would manifestly absolve Reisa from paying damages. For one, claimant isn't asking you to, quote, limit Reisa's right to take the measures. It doesn't seek injunctive relief, only damages. Nothing in Article 11.3 textually forbids that. And additionally, you would still need to consider the timing. During which period exactly could public health excuse Reisa's conduct? And if you adopt the approach that the tribunal, at least the majority of the tribunal, took in C.C. Davis, you would still need to ask, what, if any, proportion of its motives could be excused by 11.3, because compensation would still be due for the rest. So even if Article 11.3 did apply, it still wouldn't manifestly dispose of claimants' claims. So to conclude, Reisa's objection is not just unprincipled and unprecedented, it is also systemically dangerous. Accepting Reisa's submission that a state can unilaterally and without any oversight whatsoever, determine that its treaty obligations simply don't apply, will throw a hand grenade into the whole system of investor-state dispute resolution as we know it. And with that, I'll rest my opening remarks and cede the floor to Mr. Jacinto.
Thank you, Ms. Popova. I'm going to turn it back to Mr. Jacinto for respondent's rebuttal. You have 2 to 3 minutes.
Thank you, Madam President. Given the limited time, I'd like to just respond to a few points, and I'll address the others perhaps in subsequent submissions. With respect to the interpretation of Article 11.3, the contracting states certainly could have drafted it differently and included the term, say, justifiably directed, or something to that effect. They did not do so, and the rules of treaty interpretation do not provide for a tribunal to read in such a term to the clause, particularly because it would change the effect of the clause. That's why we're disputing whether there should be a good faith review or not. With respect to the criticism that respondent wishes to be subject to no scrutiny whatsoever, we do not accept that is a reason to believe that Article 11.3 does not operate in the manner we have said. Consider a sectoral exclusion. Some states do that. They say at the time of entering the investment treaty that nothing in the treaty will be applicable to, say, the natural resource sector or the financial industry. It's widely accepted that that type of exclusion is effective. They simply do not want that sector of their economy to be subject to investor-state arbitrations. I do not see how it is any different for a state to say, we do not want measures relating to the protection of essential security interests or public health to also be outside the scope of the treaty. And I think there's also a problem, more general problem, of sometimes forgetting that the investment treaty is not the only legal framework that exists. There is the state's own laws. There are state-to-state mechanisms available at times for seeking recourse. So to suggest that an exclusion in an investment treaty is somehow an affront to basic principles of international law and not providing for certain types of claims to be brought to arbitration is, I think, inaccurate. Let me pause there. There are some other issues I'd be happy to discuss with you, and you may raise them in your questions. Thank you.
Thank you very much, Mr. Jacinto, and thank you for keeping with time for your rebuttal. I'm now going to turn it back to Claimant's Counsel for her rebuttal.
Thank you, Madam President. First, to address the sectoral exclusion point. Of course, if states wanted to incorporate a sectoral exclusion, they could have done that. There are ways of doing that. They did not do that here. They can conclude special chapters, they can exclude existing non-conforming measures from the scope of the agreement, and they did not do that. The other thing I would mention is that the whole rhetoric of that underlies Rice's position here is that investment treaty tribunals simply shouldn't meddle in states' exercise of their regulatory powers. And we hear this kind of argument and various iterations of it a lot. But there, again, is little effort to actually defend the state's conduct on the facts here. This isn't a case in which we are arguing about whether the evidence that is before you is sufficient. Respondent takes the position it need not provide any evidence at all. And it's forced to take that position because the facts are fatal to its case. That the House of Cards collapses under the faintest scrutiny once you actually look at the facts, which here I would say are undisputed. Where is the evidence that a coronavirus spreads more easily at 8:01 p.m. than at 7:58 p.m.? Where is the evidence that it is more deadly when listening to jazz music than Mediterranean music? Why is late night drinking somehow more dangerous to public health than daytime drinking? Why did respondent violate its own national laws by thwarting any kind of public consultation about this measure at all? And why did respondent close Jazz Age in September, a full 6 months after the peak in cases? Could it be because recent nationals realized that life is too short to drink bad local wine and eat bad local tapas, and instead they flocked to foreign-owned Jazz Age instead? And moreover, just think of the implications that respondents' arguments would have, this argument that scientific fact and good faith are irrelevant. Think of the implications of that, not just for investor-state arbitration, but for international law more generally. If Copernicus would turn in his grave and rank economic protectionism would become the very incantation against international law obligations that the WTO panel found intolerable. So whatever conclusion you might reach on a fulsome evidentiary and legal record that may be developed in the course of this arbitration, we would submit you simply cannot import that kind of wide-ranging unilateral escape valve that would exonerate a state from having to act in good faith at the extraordinary procedural juncture of a Rule 41.5 motion to dismiss. Thank you for your attention. I'm happy to address any questions you might have.
Thank you very much, Ms. Popova, and thank you to both counsel for being so diligent with keeping time and for their thorough presentations. We would like to now spend about 15 minutes or so on questions of the tribunal, and perhaps we will start with the moving party. So we will address our questions first to respondent, followed by the claimant, and I will shortly be, of course, seeking out any questions that my co-arbitrators may have. I will start with a question for respondent. Is it respondent's position that if a state adopts a measure that purports to have the purpose of protecting public health, but is a pretext for another purpose, like essentially a sham or something else, it would be excluded from any review by this tribunal, because the only thing that matters is whether the state has, quote unquote, directed the measure to protecting essential security or public health. So my question is respondent's interpretation, or does respondent's interpretation allow the state to avoid its obligations simply by labeling the measure in a particular way?
Thank you for the question, Madam President. We do think this clause has been drafted in an unusually broad manner to take these kinds of measures entirely out of the scope of the treaty. That said, it is not our case that we are defending a sham. We have told you in our papers that there were good reasons for all aspects of this measure, including not rolling it back, the closure rule back before 8 p.m. There may be other benefits to limiting late night drinking, but as the ministry said, one of the benefits was to avoid the risk of late night drinkers becoming intoxicated and not respecting social distancing rules. There's nothing wrong with having multiple additional benefits from a measure. Now, I don't think you need to be worried about pure labeling being a risk with this type of clause. If a state were to expropriate, say, a business of a political rival and slap on the label of public health in a completely artificial way, then I think a tribunal can say that's not really directed to a public health intervention. But that's not the situation we have here. We have what is manifestly a public health measure that claimant criticizes in certain respects. So we don't have a lot of examples of this in the jurisprudence, but one I point out is Metalclad v. Mexico. And the tribunal in that case seemed to find that the decision to impose an ecological decree was a pretext to prevent a waste management facility from being developed and operated. The community had tried to challenge that facility for a long period of time and was seeming to be unsuccessful in doing so. And so someone came up with the idea, this is what I take from the tribunal's decision at least, that we'll just call impose an ecological decree on the basis of an endangered cactus in the area. But there seemed to have been no evidence that anyone was legitimately interested in that whatsoever. So I would say there is a possibility that this clause is so broad that you should not be reviewing even that kind of measure, but that's not the case that you have before you.
Thank you, Mr. Jacinto. Let me now turn to my co-arbitrators and ask if they have any questions for the respondent.
Thank you, Madam President. Yes, I do have a question. Mr. Jacinto, you were arguing essentially that if a state action is directed to the protection of public health, it is excluded from the scope of the treaty. What exactly do you mean by this? Are you saying that this exception operates to deprive the tribunal of subject matter jurisdiction? That you mean that the parties have not agreed to arbitrate these disputes? Or are you saying that the claim is inadmissible? Or is this squarely an argument on the merits, as in the merits, the measures cannot breach the treaty?
Our view is that it is best viewed as a jurisdictional question. This tribunal has the authority to review claims for breaches of the standards of treatment set forth in the treaty. If Article 11.3 provides that those standards of treatment are inapplicable to essential security and public health measures, there is no other basis for the tribunal to review a claim challenging such an action. And so I would say that the tribunal does not have jurisdiction, ratio materiae, to proceed.
Thank you.
Any other questions?
Yes, thank you, Madam President. Thank you to Council for those excellent submissions. My question for respondent is, to what extent we should be concerned that the claimant's right to be heard will be violated through deciding a matter of such import on the basis of Rule 41.5? Thank you.
Thank you. I think that's a good question. And we need to draw a distinction between the right of a claimant to be heard when the claimant is a claimant that has been given the right to bring a claim under a treaty. Now, we could raise the same objection with respect to an investor that doesn't qualify because of some limitation on nationality. Perhaps it turns on whether or not the treaty applies to an indirectly held investment or something like that. Now, I don't think that's really an issue about the right to be heard. It's a question of whether or not the states provided for such a claimant to have access to the treaty. And that's the issue we're dealing with here. Do investors have the right, have the contracting states given investors the right to arbitrate disputes relating to essential security and public health measures? And our position is that Article 11.3 clearly indicates that the answer is no. So the right to be heard, once you have established that you have access to the treaty, then of course it's an important principle, and the tribunal should take that very seriously. But I frankly don't think it's a factor that should affect the way you interpret the relevant treaty terms. In applying the Vienna Convention principles to Article 11.3, you are asked to interpret the terms according to their ordinary meaning in their context, which here it's in the context of an exclusion clause, not one of the standards of treatment. It's an exclusion clause, and I think that tells you something about how it should be interpreted. So we're not getting to concerns about due process and whether that should affect how you interpret the clause. Thank you.
Thank you, Mr. Jacinto. In the interest of time, we're now going to turn our attention to claimants' arguments and ask questions. And then if time permits, we may actually have also additional questions directed at both of you. So Ms. Popova, I'll start, and then again, I'm sure my esteemed co-arbitrators will have questions for you. My question is, you are referring to this situation as really exceptional, and for that reason, not appropriate for a Rule 41.5 determination. But help me understand what you mean by that. And in my mind, I'm seeing this as potentially working both ways. In other words, isn't the exceptional nature of this situation potentially what justifies the exceptional remedy that is found in Rule 41.5? Obviously, we've all been homebound for about a year dealing with this pandemic. And so why shouldn't we think instead that these exceptional circumstances justify, in fact, that early determination?
Thank you, Madam President. Rule 41.5 allows an expedited procedure to dispose of unmeritorious claims on the grounds that they manifestly lack legal merit. And the parties here agree that that's standard requires respondent to prove the claimant's claims are manifestly without legal merit and that its objection must fail unless it can establish that objection clearly and obviously with relative ease and dispatch. And it has to take the facts as pleaded by the claimant. Now, when faced with an unprecedented factual pattern and a clause that has rarely been invoked and even more rarely accepted, one would be hard-pressed to say that any argument manifestly lacks legal merit, let alone the claims that you have here with the record that you have here. I would say a public health crisis does not give respondents any more of a free pass. It is precisely in the times of crisis that the rule of law becomes even more critical. And so rather than canceling each other out, the exceptional nature of the pandemic and the manifestly high standard that is required under Article 41.5 actually compound and add to the high burden that respondent must meet in order to prevail on this preliminary objection.
Thank you, counsel. Let me again now turn over to my co-arbitrators to see if they have any questions for you.
Thank you, Ms. Popova. You have argued that one of the reasons why the exception at Article 11.3 cannot be brought as a jurisdictional objection is because it is self-judging. Why would its self-judging nature or not self-judging nature be an obstacle to having brought this as a jurisdictional objection?
Now, it is so. I think there are 2 points inherent in your question. First of all, it's not in dispute between the parties that the respondent can raise a jurisdictional objection under Rule 41.5. But second, it should also not be in serious dispute that exceptions like 11.3 here are a defense to the merits and not an obstacle to the tribunal's jurisdiction. And here again, I would make reference to the ICJ judgments and the WTO decisions and the investment treaty precedent I mentioned earlier, which I did not understand Mr. Jacinto to respond to. For example, the ICJ held that, quote, a decision concerning a security objection requires an analysis of issues of law and fact that should be left to the stage of examination of the merits. And similarly, the Swiss Federal Tribunal, in reviewing the Deutsche Telekom Award in 2018, confirmed that such clauses are correctly analyzed as a potential defense to liability and not as depriving the tribunal of jurisdiction altogether. So we did hear in response to one of the questions earlier from Mr. Jacinto that respondent contends that it deprives the tribunal of jurisdiction, but there is no authority for that proposition at all, and no response, I would add, to all of the authority to the contrary. So to your first question, of course, respondent is free to make a jurisdictional objection under Rule 41.5, but in substance, that objection must be doomed to fail.
Thank you.
And any other questions from my co-arbitrators to the claimant?
Yes, thank you, Madam President. I do have a question for Ms. Popova. Ms. Popova, you tell us that accepting respondent submission would throw a hand grenade into the whole system of investor-state arbitration as we know it. Should we be concerned, however, that to the contrary, allowing claimants' claims to proceed would be damaging to ISDS? It's no secret that the system is currently under extreme scrutiny, and would the tribunal not cause further harm to the system by allowing the case to proceed despite this very specific legal context, a unique and precise investment treaty exception, and this very specific factual context of a unique and devastating pandemic?
Thank you for the question. It is, of course, not our role to debate the ideology to which the state parties here have subscribed. It is not our role to second guess the wisdom of the treaty terms that the state parties here agreed. And I would submit that were we to do so, that would lead to backlash. And, you know, the system being under scrutiny is really no good reason for departing from the state party's intentions at all. All systems of justice should be under scrutiny. That would hold us all to account. But the systemically dangerous road here, I submit, wouldn't be allowing this case to proceed to an examination of the evidence, The dangerous road here would actually be what respondent invites you to do. It would be to dismiss this case as manifestly without legal merit. Just think of how high and exceptional a threshold that is. And based on what? What exactly is the justification for doing that? In your hypothetical, it would be fear. Fear that to do otherwise would lead to criticism from one of the disputing parties. And what's more, from the party that doesn't even have the courage of its convictions to defend its conduct on the merits, on the facts, from the party that wants to prevent three distinguished neutral decision makers like yourself from even looking at its violations of international law and considering whether it in fact acted in good faith. So I would submit that when justice is beholden to fear, a backlash would be not just predictable, it would be justified.
If I may interject here as well, I think this is an important question that Ms. Pasi-Panodia asked, and I, unless I hear any objections from my co-arbitrators, I would like to direct the same question at Respondents' Council just for the 2 or 3 minutes that we have left. Do I see any heads nodding in disapproval? Okay, so Mr. Jacinto, please, if you don't mind, and if you'd like us to repeat the question, we're happy to do so, of course.
I think the context can't be ignored. We, as I said, are dealing with a pandemic. The measure was unquestionably originally adopted as a set of measures meant to stem the pandemic. And the only real criticism is that the decision to roll back the measure to allow indoor dining and drinking up until 8 p.m. was improper for various reasons that claimants have alleged. Now, I don't see that you need to rely on fear or be concerned with criticism. You never need to get to that stage. You just need to be assessing the terms of Article 11.3, again, in their context as an exclusions clause, to assess whether the measure is a measure directed to the protection of essential security interests and public health. And on that note, I'd say that we've been attacked a few times for not doing enough to engage in the facts. But this is a Rule 41.5 hearing. It's effectively a summary judgment procedure. We're telling you that the facts as pleaded by claimant make it abundantly clear that our objection stands because it is a measure directed to public health. The fact that it may be unfair to claimant and that its business suffered worse than restaurants because it's a nightlife business is irrelevant to that question. All that they really have is this allegation that this all may be some conspiracy to apparently expropriate or harm this business to benefit, I suppose, competing local restaurants. But there's no evidence before you. This is, again, not like the metal-clad case where there seemed to be evidence that that ecological decree was a sham. Thank you.
Thank you to both of you. We have just short of 2 minutes left. Let me turn to my co-arbitrators and see if they have any additional burning questions they wish to ask in these 2 remaining minutes. Hearing none, then I would like to thank again both counsel for their excellent presentations, and I'm going to now turn it back to our moderator. Thank you very much.
Thank you very much to our Madam President, to our esteemed members of the tribunal, to our outstanding counsel on both sides. I think this is a really illuminating argument, and I want to say a few words about what we may be thinking at the end of this. But let's go ahead while I'm talking and launch the poll, which is the same question that you saw earlier. Now, having watched this argument for the past hour, do you think the respondent's objection should be upheld and the case dismissed? That's the question before you. You're not going to get to hear a ruling from our esteemed tribunal. It is up to you, the audience, to decide the fate of Jazz Age. So while we're collecting that poll, I want to say thank you again, and I want to talk a little bit about exceptions and flexibility. right? So what we've seen, if you breathe the oxygen of the investor-state dispute settlement world over the past year, one preoccupation among scholars and practitioners has been the ways that investment law affords flexibility for states to respond to crises like COVID-19 or like the climate crisis or like any other crisis that is looming on the horizon. And one answer is exceptions. Exceptions provide that flexibility. And we can now see from this discussion a lot of ways that that the answer is more complicated than that, right? So the first question is, what is an exception, right? What does an exception do? Is an exception merely an exception from liability, which I believe is what the claimants are suggesting in this case and what we would expect in a real case to be suggested. And therefore, the case should proceed and we should really find out whether these are measures directed to public health or not. Or is it an exception from some or all of the burdens of litigation, right? In which case it's suitable for a preliminary objection of some variety or the other. The second question is, what is the procedural mechanism by which that exception is going to be operationalized? Is there some mechanism like there is in the ICSID rules for a preliminary objection? Do we need to be drafting different forms like you see in some new bilateral investment treaties, for example, in the United States, for a Rule 12b6 like procedure that is a little bit more flexible? Are there other means like bifurcation that could be available as well? And how does the procedure link up with the substance here? And finally, I think that that's something that comes up in the context of these cases is what are the other options on the table, right? What other ways do we provide flexibility? Are ways for example, for states to get together and issue joint interpretations of their treaties a way to provide flexibility in these extraordinary times? Are there mechanisms like a suspension of arbitration during a crisis period that has been proposed during COVID-19, something that should be considered? Or should we step back from the brink of flexibility, as the claimant is suggesting, and say now is the time for non-arbitrariness, and now is the time for reasoned decision-making where cool heads prevail, and investor-state dispute settlement has a role to play in that. So those, I think, are the questions on the table, and those are the policy questions going forward. Maybe not for this crisis, because the fact of the matter is we didn't adjust our treaties before COVID-19. But maybe for the next crisis, we should be thinking about institutional design and how these three questions link up. So again, I think this has been a fascinating discussion. I think there's a lot of food for thought here. I think there are probably other questions other than the ones I discussed. I sort of left on the table a lot of technical legal questions, and we did not have time to get into all of the ins and outs of security exceptions. If this is an issue you studied, you know that we left certain legal questions on the table. I am now seeing that we have about the same number of votes as last time, and we have 63% of you would uphold the objection and dismiss the case, and 38% of you would proceed. That is essentially what we'll call it a 2-to-1 vote by the tribunal to issue a final award in favor of the respondent. And so we will close Jazz Age LLC and then see how it affects the next case. So thank you very much for joining us today. I see the countdown clock is ticking down relentlessly. I want to thank ASIL. I want to thank our esteemed tribunal, Madam President, and our council. This has really been an illuminating discussion for me. I hope it has been for you as well. I will be in the continuing the conversation room for the next little while. And I am looking forward to joining you guys there. So thank you so much, and a round of applause. Thank you, guys.